Good morning, everybody. This is the MLAC Subcommittee on Worker Continuation of Care. Today is Friday, October 28th, 2022, and it's at 10 a.m. We'll start the meeting with reviewing the minutes from the October 16th meeting.
Just a clarification, I believe it was the 14th.
Oh, the 14th. Okay. At the yep, you are correct.
I have no issues, Matt. Did you?
I have no issues with those minutes.
Okay, I so move.
Okay.
I second.
Okay.
And we're all in favor.
Okay. So,
Approve.
okay, approve. Okay. And so people, those in the audience in the squares, we will get the minutes uploaded as soon as we can after this meeting. Let's see, introductions. Let's see, I think I'm going to skip through that because I'm looking through here. We don't have anybody specifically invited to speak to the committee. I think this is going to be more of a roundtable style. And I think from looking at the squares, most everybody, if not all, have been to the subcommittee meetings before that. So shifting gears to the update on information requested by subcommittee members. So you had asked WCD to look at, do a comparison of other states with a series of questions in regards to temporary disability authorization. So on the website, on the committee webpage is a summary of the responses that have been provided. There's a memo that does a summary with specifics on the questions in the states that had information that's of interest to the subcommittee. I have not, to be honest, I've not had a chance to go through all of that, so I can't quote everything there. And then there's also a matrix of specific responses from every state and a list of all the states that had responded to WCD's information request. I believe there are representatives from the division that are here for questions. I'm not sure if we wanted to do a walkthrough of the findings or not.
I'm not opposed to doing it. I looked them over. I don't have any really clarification questions or anything about them.
Okay. Okay, that works for me. Margaret, Tammy, do you have any questions for the division? Sarah?
Not on that specifically, but I would love to hear if somebody's there to walk us through that. I would love that.
Okay.
But if nobody else thinks it's necessary, then that's okay.
I apologize. I ran out of time. I could have done it myself, but I ran out of time to provide a proper.
I tend to agree with Tammy. I would find it helpful, but not necessary. I would just be interested in what struck other people also.
Okay. Let's see. I'm just looking and checking if I have any messages or anything from the division. I do not. And we can I just go into the discussion, and if need be, if there's things that are related to the questions in the survey, I can point those out throughout that as well. Okay. So the next item on the agenda is stakeholder proposed solutions for the updated problem statement. And I will, this was printed on today's agenda, but I will put this in the chat as well to refresh memories of what this is. So the committee members have asked for stakeholders to come forth and talk about a piece of commonality that came out of the discussions from prior subcommittee meetings. Specifically, proposed solutions though, so that all workers, specifically workers with open-ended time loss authorizations and those who are not seeking treatment, remain connected with their provider, and to minimize gaps or delays in treatment when they are off work or return to modified work. So
Maybe Matt and I can speak to that briefly. You know, we were wanting to refine our problem statement. So we deal with the problem that I think everyone agrees that we have, that it's the workers with open-ended time loss authorizations and those who are not seeking treatment. So, you know, at this point, I think we're looking for a solution, and we'd love to hear ideas from stakeholders, if, of our new updated problem statement. Matt, do you want to chime in?
I think I agree with all that. It's from what I think there's been agreement on. There's a very small subset that are not seeking treatment and also not having any kind of defined time loss. So we would be open to hearing stakeholders' proposals.
And that's Dustin Carstetter. Good morning.
Good morning. I just wanted to start by echoing something that that Tammy had brought up at the last MLAC meeting. And while I know that this won't directly address the problem statement that we're looking at, but I feel like one of the areas, and to Matt's point, where this is a kind of a small subset. I mean, this is definitely the exception and not the rule of individuals who are not actively seeking treatment. But it seems like within that, there are a lot of loopholes that people can find. And Tammy kind of identified the bug letter, the B9 letter, and how there really isn't any teeth to it. Really the only expectation on the worker is that when they get that every 30 days, if they're not actively seeking treatment, is if they fill that out saying that, yes, I intend to seek treatment and here's my proposed appointment with this doctor. That's all they have to do. And then nothing can be done for another 30 days until we find out whether that visit actually happened. I know that there's not, that's not the only area where people can, for lack of a better term, game the system if they want to. But I feel like closing some of those loopholes will kind of redirect those individuals back to actively trying to seek ongoing treatment, rather than allowing those situations where people kind of fall through the cracks and there's not really a mechanism to keep them actively treating or to hold them accountable for that process. I mean, when somebody's off of work, their job essentially is to get better. They're not working, so they have that, at a minimum, those 40 hours a week to fill, and that should be spent trying to understand the system, trying to get in contact with doctors, and actually going to appointments to try and get better. So, again, just to echo Tammy, I think that's one aspect that can be looked at, but I think trying to identify some of those loopholes where people do fall through the cracks, whether actively or accidentally, would really help kind of redirect the direction, or redirect people towards active care and trying to identify who they can see and how they can effectively work towards recovery.
Thanks, Dustin.
So that is definitely a proposed, at least conversation point. And, I think that's worth exploring as a potential to close a loophole. Any comments on that, or other comments on something to explore?
Are you asking for comments on this specific issue or all the different ideas of solutions?
Yeah, I think we're looking for recommended solutions. So anything that we can put out there, I think this is our time.
Well, I just would like to second, I don't know, Dustin, about maybe looking at bulletin number 9 and, getting a few revisions on that. So it's a little bit tighter. And so there isn't a loophole there. I think that would help a lot. So I just wanted to chime in on that.
Would that be a stakeholder discussion then, to come back with a recommended solution that would work?
Wording, you mean wording in the bulletin number 9?
Mm-hmm.
I would assume so. Elaine has her hand up, so maybe she can speak on that, or unless Teresa knows the answer.
Nope, I was gonna call on Elaine next. So, but I was actually I was tracking down the bulletin actually, so I will do that.
Yeah, that would be great to send bulletin number 9 to everyone.
Okay.
That's why it's called a B9. I call it a B9 instead of a bug letter. I don't like that term. That's just me personally. Okay, thank you.
Hi, Elaine Schooler with Safe Corporation. The idea to modify the bug letter is certainly an interesting one, and that's a discussion we're willing to have about what possible changes could be made to make it more enforceable and a useful tool for the situation. We've previously brought forward ideas surrounding open-ended authorizations, initially proposing a 30-day requirement for time loss to be addressed. We've heard lots of feedback about why that may be difficult for workers and potentially providers. And so we had modified and presented another idea that was discussed at the last meeting to some degree about just having providers provide an end date when they're authorizing time loss so that it's laid out at the time the authorization is created. And that really aligns with the notice requirements that are going to be in place for employers in 2024 as a result of the House Bill 4138, and allows employers then to give appropriate notice to workers in advance that time loss will be ending, and workers can then take appropriate steps to ensure that there are no gaps in their time loss benefits, and that they're maintaining that regular contact that's so important with their medical provider. That concept too also aligns with feedback from the Medical Advisory Committee, MAC, that open-ended authorizations really aren't a best practice or a good idea for workers who are on time loss benefits, and that there should be an end date on those authorizations. So we do have that idea that we've brought forward. Again, like we've modified it, are interested in having further discussions about it. In addition, another idea that was brought forward was to have MAC engage in a best practices either statement or notice that can be then provided to medical providers to instruct them that regularly addressing time loss benefits and providing end dates is what is MAC's recommendation for all providers in the system. Another idea that we have been discussing about more recently, we still need to vet it internally and externally, is to look at providers and potentially modifying the statute to require providers to include an end date on the authorization as part of their documentation of visits and care in order to have their bills be reimbursed from the insurance carrier. And that if there is no end date specified on the release, then payment would be withheld until it is subsequently provided. And that tracks along with the verifiable information of an inability to work that's in 6562624F. That has limited success, but would get to this issue as well, and is another possible solution we're willing to talk about. I'm happy to discuss these and or let others chime in as the co-chairs so feel.
I did have a question. You mentioned limited success, and I wasn't. I'm not familiar with that statute exactly and why it had limited success. That has to do with providers then?
It's a statute that allows for medical billings to not be reimbursed until the provider gives the insurer verification of the worker's inability to work. And that it was a statute pointed out by the trial lawyers as one of the tools available to carriers. It's not a tool that, from our perspective, really works that great when a worker is not regularly treating with their provider. More often than not, the provider won't comment on the worker's ability to work. They'll just default back to whatever the last work release was until they see that individual and have the ability to have the check-in and see how they're doing.
Thanks.
I have to apologize to all of you. My computer wigged out. Like I couldn't see the screen for a couple of minutes. So I missed some of the conversation. I apologize. But I'm glad that the meeting didn't end. Because
Elaine, can I ask a question on the new thought that would require providers to put an end date? Do you feel that this would be helpful and push it on the provider versus the worker? What was the hopeful end result of that?
Yes, I think so. I mean, this is an early idea. It hasn't been fully flushed out, but yes, the thought is not to create a burden on the worker, but rather to basically create a consistent practice amongst all medical providers, and then use their billing as a means of ensuring compliance, so that time loss is being appropriately addressed with beginning and end dates.
Thank you.
You're muted, Teresa.
sorry, when your computer almost crashes, you're going to discombobulate for a couple minutes. So Dustin, did you want to speak to this particular topic, or is another?
Yeah, to this particular topic in relation to what Elaine had said, and kind of going back to, the overall problem statement of, what do we do for continuation of care? And obviously we want to find something that doesn't put, an odious burden on the worker. We don't want to make it a system that's contentious and find ways that, we're essentially kind of tricking workers into not having the benefits they need because we're making the system so hard. I do like the idea of putting more of the burden on the providers. And, I guess the question I have from my time as an adjuster, I'm more on the employer side now, and I know somebody did an intro. I'm with Washington County as a risk management analyst. Is the fact that we have statutes that are supposed to lay out kind of what each party is supposed to do. And I remember there being statutes in regard to what was required of a provider. And Elaine mentioned how there hasn't been a lot of success with being able to hold the providers accountable, even if there is something indicating that they are required to have an end date and potentially they could have their bills not paid if that is missing. And I mean, would it be possible to, in addressing this issue, to really beef up that those statutes hold weight? And if there's not something in the statute that does mandate that an end date is there, otherwise they're not going to get paid, that we really enhance that statute to ensure that that is a requirement, that's not just something that could apply, but something that will apply. And roll that out to all the carriers so that they're all aware of what the new expectation is. So I'm just curious, I mean, if that's something that we can focus on, is any of the statutes or any rules that are already in place governing how providers within the state are supposed to address workers' comp, of really enhancing those and ensuring that those are held to account. One other question I had kind of related to that is, I understand one of the common things that I always heard, especially from workers, was we've tried to reach out, and so many of the doctors that we called say we don't take workers' comp. So it seems like there's a shortage of physicians, PAs, chiropractors, whatnot, that actually handle workers' comp and are versed in workers' comp. Is there any way that from the state side of things that we can mandate a certain percentage of providers within the state are required to take workers' comp to ensure that a worker doesn't run into that wall of constantly reaching out to people and finding that either they don't take workers' comp or they've filled their quota, they're not taking new workers' comp patients, to help address this, because I'm sure that it's very discouraging for some workers, and that can lead to them not actively treating when they call 2 or 3 doctors' offices and find that there's just no way that they can see within a particular network, with an MCO, what have you, just to ensure that we're requiring more people to adhere to the Oregon fee schedule and have to be part of workers' comp to ensure that there's not that shortage for workers.
So I think you've hit a point that we should be mindful of, and that is that providers may, I don't know if there's any providers here today who could speak to some of these ideas, because I think there could be some concerns with folks that don't already want to really engage with work comp, and if there's a punitive thing in there. So I'm just curious if there was discussion about, rather than withholding payment, well, I understand, I guess, for not putting the end date, that is an omission that needs to be rectified with some providers. But most of our discussion is around making sure that there's timely, consistent engagement with their providers, and looking at how things have worked in healthcare elsewhere. Is there a way to maybe incentivize, rather than a takeaway, but saying, hey, you get a increase in your reimbursement for Medicare, or I'm sorry, for work comp patients that you see if your engagement is this, or if you meet certain metrics that we know are tied to engagement. And I think that's where we would want to go to the MAC, is say, okay, you have these best practices, and then what are the outcomes that these best practices are tied to? So is it returning to work in a more, I mean, I would think from the work comp stance, it's returning to work in a more timely fashion, and getting resolution faster. And so in respects that employers who are rewarded for avoiding injury, right, their insurance costs go down and they get rewards for that. Is there a way to find providers and reward them for getting patients better faster, or at least maintaining a certain amount of engagement that the MAC would define as, this is the best practice, this is where we see kind of that point where folks tend to be getting their optimized level of care. So I'm just curious if that's been discussed, maybe as a consideration for an alternative to being, we're just not going to pay you, to being something like, if you're meeting these best practices, you'll get a little bump in what the standard payments are. I mean, money tends to motivate people, right?
Sure. I mean, that's certainly another idea. Best practices are best practices, and if they're not being followed, then the doctor's not adhering to best practices, similar to submitting billing statements and not providing all the required information. If the goal is to ensure that doctors are actually following the best practice when they aren't, then withholding payment seems to be potentially a reasonable solution. And conversely, for those doctors who are following those best practices, they're getting paid as quickly as they submit their information to the insurer. So that is their incentive, is to follow what's been already determined a best practice. And when they're doing that, they get prompt payment. And when they don't, they need to rectify that and correct the information being provided.
Morning, David.
Hi, and I apologize, my camera is not working. So I spare you all. Just to amplify a little bit on what Elaine said, and Matt, to ask you back a question to that. It seems, I think the idea that was thrown on the table by Elaine is one that just had yesterday, and was trying to target, if we have a small number of a percentage in the system where there isn't that tie to care or the follow-up scheduled or whatever, here's one way of doing it in a way that seems to be within, there are a number of things that happen in billing where for medical providers that gets regularized. And if there's a problem, it goes back to their billing department in a medical office, and they do X, Y, or Z to correct. It doesn't require another visit. It, is something that sort of gets incorporated in the way business is done. So we don't see it as onerous, because there are other billing requirements and glitches, and they just sort of get built in. But the question that you ask, I mean, and then my question to you was, is it what you're asking is something different than just for this particular circumstance? Is it looking at, should there be some other broader way that we're looking at the system and incenting the system and structuring the system to payments to look at best practices? Is it a bigger something that you're wanting to discuss and look at?
Yeah, that's a good point. Maybe it exceeds scope, but I think looking at, considering the problem statement, it's about, I view it as it's continuous improvement. This isn't a static situation. There's always innovations and things that are happening. So rewarding those that meet the best metrics, which I would refer to the MAC on, what are those metrics, and how are they related to frequency of appointments and connections to the attending physician, and specifically the attending, because that's what this all comes down to, I think, right, is that contact with the attending, because there may be things that are not being done, that are not captured, but in relation to having the attending physician's office coordinating other care, be it MRIs, physical therapy, procedural care, that they may be able to engage more actively to move the patient along faster. Are there things like that, so that they're maintaining? That's why they would be having that consistent engagement, and then they get a reward because they are helping move the patient or the worker through faster, and in a way that gets the worker, because what I've heard over and over again is the evidence is really clear that the sooner the worker is back engaged with their work environment, the better they do. And the more time away, then there's like this, it almost sounds like there's a precipitous drop in their ability to ever get back to that work environment. So I don't know if that is taking the scope too far, but it seems like that's what we're looking for, is making sure folks are seeking treatment at the right times, and that's going to be directed by medical professionals who know what they're doing. And we can talk here about what we think the system looks like, but I believe that the system for the frontline physicians and stuff is pretty hectic and overwhelming, and so they probably need some incentive to be innovative right now, because it's just struggling to get through their patient loads every day.
Finally, I'm unmuted. Okay, Paloma, thanks for your patience with me today.
Thank you. So Paloma Sparks with Oregon Business and Industry. We're the state's largest comprehensive business association. And I sort of want to take us back to how we got here. So we were heavily involved in House Bill 4138, which passed earlier this year. Our members had a lot of concerns about it when it was brought forward. It was brought forward by the trial lawyers who said, here are some problems we see and we want to see these fixed and changed. We didn't feel great about the bill, but we gave up a lot to reach an agreement with them. And the agreement was based on a commitment from the trial lawyers that they would negotiate in good faith. So what employers gave up was changes to notice requirements, eliminating the ability of physicians to retroactively declare a worker to be medically stationary more than 60 days prior. Time loss can be retroactively authorized for up to 45 days. And it limited the ability of insurers to collect overpayments in both time and amount. So there are circumstances where those overpayments are just overpayments, and we're going to have to accept that. So the bill changed a lot about our system, and all that we asked is that we all come to the table and we address this issue that's very important for employers and insurers. There was a commitment to negotiate specifically about open-ended time loss. So we put a lot of proposals on the table. We asked for 30 days. that was rejected. We've put some other proposals. You've heard from Elaine today, some new proposals today. So what we're asking is that they put something on the table so that we can have a true discussion. We still have not received any real responses except for no, and we don't like that. As discussed by stakeholders, including MAC and the Small Business Ombudsman, open-ended authorization should not occur and can result in poor outcomes for workers and expenses for employers and insurers. We're only asking that they provide some meaningful proposal so that we can move forward with a true negotiation with the goal of keeping the system balanced for workers and employers. Thanks.
Ryan, Keith. I have Keith and then, yeah.
Good morning. Paloma has a much more expansive recollection of what we agreed to do when we went through the prior negotiations on the prior bill. We said that we would show up, we would participate, we would discuss the ideas, we would continue the discussion. We've done all of that. We were very clear from before the 4138 discussion that we would not support a 30-day closed limitation on time loss restrictions. And we really haven't heard any other ideas or proposals. We've suggested that the existing tools be utilized, or maybe a little bit of additional intervention on specific cases might be appropriate. Counseling doctors, writing letters to doctors. We've gone over the various things and given proposals of what could be done with the existing tools and how to use them. But we never did agree to come in and start negotiating on 30-day closed limitations on time loss. And frankly, this is the first meeting of all these meetings that I've heard any other ideas come out of the defense side. So, I mean, I don't know where that leaves us, I guess miles apart as usual, but I think that last session with our 4138, we brought forward some very clear disparities where workers were getting surprised and then having benefits taken back. We outlined the problem. We tried to tailor the solution based on feedback. We brought that back. We explained why we thought the problem was there. And there was agreements that were reached on how to address the problem. But there wasn't an agreement that there was going to be some sort of quid pro quo that we were going to come and propose new solutions and agree to proposals that were on the table. We're not no on everything, and we've given some ideas on what could be done within the existing system. And I'm hearing some interesting ideas this morning about other things that might be done within the existing tools to kind of work around the edges and see what we can do for this small subset of workers. But I will come back again and again to the idea that this is a very small subset of workers that are dodging their doctors and not getting appropriate care and forcing employers to keep paying time loss when they shouldn't be. And there's a lot of tools in the tool bag. I know everybody feels like they're either too effective and therefore too harsh, or too ineffective and therefore useless. I've heard both. I'm not sure what to make of that, but we're still here. We're still talking. We've given ideas from our perspective on how this really pretty narrow problem needs to be addressed. And we're still there, and we're still here talking about it. I imagine there will be more discussion on some of these other proposals that are being floated today. But our thought is that the insurers can go directly to the provider and talk about the need for closed-ended work restrictions, for follow-up, for confirming the inability to maintain work restrictions if a worker keeps dodging the appointments and missing the appointments. I saw just the other day a nurse case manager was involved in that discussion. That's something that hasn't come up a whole lot in this discussion, but I think that is a potential solution that's already available. So we see a lot of potential solutions that are already available. We really didn't see those potential solutions already available to workers when we talked about the problems in 4138. So I think we're really talking about a false equivalency here. That's fine, that happens, but that's our perception of it, that it's not just because one got passed and one was adopted that something has to be done on the other side. We understand it's an important concern for insurers, and that's why we're going to continue having the discussion and see if there's something that we can all work out. But the agreement wasn't that we were just going to come and say, okay, we're going to hash a deal out on something that we're still concerned about, whether it's really a big enough problem that it's happening often enough that really we need to have a major change in the law to deal with.
Keith, this is Sarah. Thanks for your feedback here. With the subcommittee updated problem statement, we are asking for recommended solutions. And can I get an opinion from you or feedback on what you think of, I have 3 kind of written down, going to MAC for best practices, working on the B9 letter to redirect and maybe close some loopholes there. And then a potential more vetting necessary on a statutory change for beefing up the statute for the requirement for billing. Can I get your thoughts there on those 3? Those are kind of where I see that. Maybe Matt can chime in if he's seen anything different on the table thus far.
Yeah, I think that those are much more tailored approaches than 30-day or 60-day limitation on open-ended work restrictions. I do see those as a move towards thinking about the situation that the worker is in relation to their doctors and putting the focus more on what the providers can do with some education and some counseling. So I'm open to further discussion on those things. I mean, I wouldn't say that we've just kind of set our piece on that the way we have the 30 days. I mean, that's really the thing that's been discussed most and floated kind of informally, but then not then formally, then kind of informally. We've got strong thoughts on the 30 days, and that's been the topic of most discussion, but we're interested in engaging around the particulars of these things that are being floated this morning. We haven't had a chance to talk to our group about any of those ideas because we're kind of hearing new approaches for the first time. We didn't really know what we would hear this morning in terms of list of proposed solutions. We envisioned that it might be the same thing that we heard in the past that we've already kind of set our piece on. So like I said, we're still willing to engage. We're still here. We're not saying that we're done talking about this after the subcommittee breaks for today. I imagine there will be further discussions, and let's talk details.
Great. Thank you for your willingness to show up. We appreciate it.
Okay, I'm looking to see. Actually, I'm going to re-ask what Matt's asked earlier. If there's any provider representatives in here today that can speak to some of what's been discussed so far, that'd be very helpful. I can actually, Matt and Sarah, I can do some follow-up with some of the representatives I know from the various medical groups for feedback. I can try and get that as an alternative. I know we're running on tight timeframes. Does anybody else in the virtual room want to provide feedback solutions? Okay. Hi, Tammy.
I'm trying to process here Keith's reply to Paloma, because Paloma's recount is kind of my recollection as well. And I know that when we voted on that bill, we went online, or I mean, we went on the record saying, and before we voted, and I was the one that had nominated to approve that bill. And I remember very specifically, we went on record with what we were asking for regarding this. And so I think that we could probably pull that transcript to kind of look and see what we had agreed or what our marching orders were if needed. If it's, I mean, we don't want to argue or anything like that. So if it's not necessary, that's fine. But I know that we had agreed to find a solution. That was my recollection, but maybe I don't know, maybe we should just review that. Or maybe our mission statement just cancels it out, but I just kind of wanted to echo what Paloma had said.
Elaine?
Hi, I wanted to add in of the potential solutions that Sarah mentioned. One that had been brought up before, certainly at the last subcommittee meeting. And again, I mentioned it earlier, but it didn't get put on that list, was just putting in a requirement for doctors to include an end date on their time loss authorizations. That takes away, not including the billing piece. That's a separate concept that goes to the same issue as well. But that's also a proposal that was brought up certainly at the last subcommittee meeting. I think the 30 days, that keeps coming up, but I have not heard management really pushing for that in these meetings or asking for that. I don't see that as something that really needs to be discussed in any more detail because of these other ideas being brought forward.
Dustin.
Yeah, looking at going off of what's recently been said, in terms of the time frame idea, a 30-day, a 45, a 60-day. I guess I don't see the reason why there would be significant opposition to negotiating out what a proposed time frame would be, partially because, again, it's a complex issue, and there should be a multi-pronged approach to addressing and trying to fix it. And I think when not coming to an agreement on what a basic requirement would be for whatever that time frame would be, whatever the number of days that somebody's required to get the next authorization, it still kind of fosters that system where you would still have people kind of falling through the cracks of providing an open-ended time loss. And again, whatever that date ends up being, it would seem preferable that both sides can come to some basic agreement. Maybe there's exceptions built into that of what would, circumstances where that wouldn't apply. But again, trying to close any of these loopholes that allow people to kind of fall through those cracks, I think is beneficial. And then kind of going back to one thing that Matt had mentioned earlier, he'd made the reference to something being punitive, and I think it was on the provider side. And obviously within the system, I mean, nobody wants anything that seems to be punitive, but I mean, that's also kind of in the eye of the beholder. When a decision's made by an employer in conjunction with their insurer and it gets appealed, and the defense attorneys fight for something and a penalty gets applied, that can seem to be punitive. I mean, there's things that may be punitive within the system, whether intentionally or unintentionally. But I do agree that building in some sort of reward system, you can always kind of look at something as either the carrot or the stick. I mean, there's always has to be some sort of incentive built in, and whether it's somebody being pushed or pulled along. I think that looking at building in some sort of grading system or reward system on the provider side would potentially be a necessary aspect to trying to correct this issue. Just because, obviously in the state of Oregon, employers cannot direct care. So, I mean, we are very reliant on the providers. And if there's not some ironclad, whether it's requirements or best practices built into the system, it's kind of a lose-lose situation, sometimes for the worker, sometimes for the employer. And, in the middle of that is the provider. They have, an exorbitant amount of control over how a claim goes, and not having a really defined set of, again, whether you want to call it or define it as requirements or best practices to hold them to, it really allows for a lot of ambiguity and a huge gray area in terms of how some of these problems are addressed and how effectively claims as a whole can be overseen.
Thanks, Dustin. Well, if there is one last call for feedback before we switch over to subcommittee discussion. Okay. So we'll dive into the subcommittee discussion now.
That's us, Matt. I personally like the creativity brought forth today and looking at it from different angles. And it seems like stakeholders are willing to further those discussions, and kind of in the early stages. And maybe we could ask them to go back and kind of hash out what it would actually look like, and then bring a report back to us in a defined time frame. What do you think, Matt, or where you're at?
Yeah, our next full MLAC is November 10th, right? And we have to provide something to the committee then. Our subcommittee has to come up, right, provide something. And it seems like that would be a reasonable recommendation, is that stakeholders look at this from the proposals today and talk about that. Because I'm sure there's a lot of nuance in there that I'm not aware of with all
Right.
statutes, and I like that Tammy called it the B9 rather than the bug letter. That does seem far more appropriate. So, looking at the B9 and folks getting the table seems reasonable to me. And would that be our recommendation on November 10th, or our report out as we have sent it back, and would look for a date to have them? Or
I'm a little more optimistic than that, Matt. What if we could get some sort of, could we get a commitment that they could meet sometime next week and give some sort of written report to us, or something? I mean, I really would like to be able to go back to the full MLAC on the 10th with something, if we can. I mean, I think we've made great strides today with at least some acceptance on both sides that there's some interesting options out there. If they could vet them and come up with something, I don't know, could we ask if they could meet next week?
I'm not opposed. I don't know if I would have much time between now and the 10th to
Right.
dive deep
No, I
into
don't think maybe we could meet, but I think they could meet, and then maybe I just saw the agenda, or a draft possibly, that it didn't seem, Teresa, maybe there's a lot on it. What if we could use some of that time to further our subcommittee meeting based on what stakeholders could do, and then we could go into a full MLAC after that and go see where it goes.
I think we can, with the sign off from the co-chairs. I know that the legislative review pieces follow up from our last meeting, full meeting, which the other stakeholders that we know of that have concepts may or may not be ready. So it may be a light agenda even more depending on pieces, but I don't think that would be a problem.
So maybe we could use some of that time for a subcommittee meeting if the stakeholders could commit to meet in the interim and provide some sort of written update to Matt and I, and see if we can get somewhere. What do you think, Matt? I mean, I don't know. I guess we have to ask them if they can meet.
Yeah, I see Keith has his hand up.
I was raising my hand to say that we're happy to try and get some of our membership together to have a meeting like that between now and the next MLAC meeting, and start vetting and discussing details about the concepts that we heard about this morning.
Thanks, Keith.
I see David's hands raised as well.
Same for SAFE. We're happy to try to get together and work on this next week.
I have a clarifying question, just to make sure everybody's on the same page. So the proposals that the stakeholders are to work on. So this is my list. I may be missing items or have too many. There's the MAC, consulting with MAC on best practices, and then doing next steps on codifying that as much as we can be codified. Looking at current statute in regards to the bug letter and closing the loopholes there on that. And then statute specific to billing practices. Is there anything else besides those three?
It was the physician setting the time off.
Oh, that's
date,
right.
The
Okay.
requirement that the physician set the time off.
Okay.
Date.
Okay. Also too, I'm just throwing this out here. So as part of like working, getting the information synthesized for the final report, I have a working draft of current statutes, like what the current tools are in statute and in corresponding administrative rule. And that touches on some of these. So for example, the statute specific to the billing and the, and the conditions in which a provider can have their payment suspended. The bug letter is not stated as a bug letter, but it meant there's two different sets of statutes and rules in regards to the notice. I don't know if that's would be useful for folks. I actually have it in PDF form. I can put it in the chat and we can upload it to the website.
I would appreciate that.
Okay.
Yeah, I think if
Can
you
you-
upload into that, that'd be great.
Okay.
Can you also include the actual bulletin number 9?
Yeah, as I've been texting back and forth with division staff. So we're looking, so we're looking at that right now. So,
Thank you. Okay.
Okay.
Thanks.
we'll just take, hopefully my computer will not freeze as I upload this. Okay.
So I think for Matt and I, knowing what we're getting into on November 10th, it would be helpful for some sort of status update from the stakeholders before that November 10th meeting. So we can kind of see, or at least kind of have an idea of, the traction that's been made. Is there someone that could, synthesize that for us after the stakeholders meet?
And what do you think would be a reasonable time to get that?
Well, I'm looking at the calendar. We have, and if they could meet next week, could we get something by the end of the day on the 4th? Is that next Friday? Elaine, you have your hand up.
Yes, yeah, I'm happy to volunteer myself. I can coordinate that and following discussions with the other participants, circulate that, a summary to ensure we have consensus and then provide it to the co-chairs.
Do you think the 4th is something that could be doable? So we have a little bit of time and then maybe Matt and I can meet on that before the 10th?
I think so, barring any major scheduling issues amongst the parties, but we have done similar subcommittees of subcommittee groupings before and been able to act quickly and have these discussions. So I'm confident that we can do the same in this case.
Great, and we see Keith's got a thumbs up too, so. Matt, do you have further thoughts?
Nope, that sounds good. That would be plenty of time, I think, to review it, and then we would just have to find a time to meet before the 10th.
Yeah, and I mean, we could do that fairly informally, just you and I, and after we can read the synthesis document.
Okay.
And I'll work on getting changing the modification on the full agenda and getting a subcommittee on before the full on the 10th. Okay.
Does that work with your schedule, Matt? Just using a portion of the MLAC meeting, let me see.
That would be best, yeah, I think.
Yeah. Not adding another meeting, but just carving out some time for that.
Yep, that'd be best, for sure.
That works for me as well.
Okay. We'll make it work.
Okay.
Okay. Is there anything else for the good of the order? Thanks, everybody.
We appreciate movement and we appreciate, the creativity and the groups and stakeholders willing to further discussion to, address our updated problem statement. So on behalf of the subcommittee and Matt and I, we thank you.
Yep, thank you all very much.
You're ready.
Okay. Have a good day.